Welcome to Building Families, Bridging Differences, a family law journey.
Hey everyone, welcome into an all-new episode of Building Families, Bridging Differences, a family law journey with attorney Shelly Booth-Cooley. I am your host, Mike Leon. You know, Shelly here, she's a certified family law specialist, and she's the founder of the Cooley Law Firm out in Las Vegas, Nevada. She focuses exclusively on family law, helping clients with divorce, custody, adoption, assisted reproduction, and she's known for her compassionate, straightforward approach. Today's episode, we're going to be talking about how community property works in the state of Nevada and what people should understand from the very beginning about the divorce process. Shelly, it's good to see you. As always, Happy New Year to you. To start here at the onset, I would love for you to give the 30,000-foot overview and kind of explain what community property means under Nevada law.
Thank you for having me, Mike. I hope that your holidays and New Year have started out nicely.
Thank you.
And that's a very good question. What is community property? And some folks may know, a lot of folks may know, and they've heard this word thrown around a bunch probably, but Nevada is a community property state. And what that means is that assets and debts that are acquired or incurred during the marriage are community property and divided approximately equally upon divorce.
Okay, so now we know that. And I'm sure a lot of people have come to you and assumed that everything was 50-50 divided equally. So in that case, how does Nevada actually determine what belongs as part of the marital estate?
Well, what belongs in the marital estate are assets and debts that are acquired while folks are married and are not subject to a premarital or postmarital agreement. And the reason I have that clarification is if a premarital agreement governs an asset, then that is going to preempt what our community property law says based on contract principles. And the same goes with a postmarital agreement as well.
Shirley, let me ask you about separate property. What kind of asset? Well, first explain separate property for folks out there, but also what kind of assets kind of qualify as separate property? What needs to happen for them to kind of stay as separate property?
Well, a few things. So first off, separate property is a very distinct classification. So separate property are assets that are acquired by inheritance or personal injury settlements or gifts from from a spouse or from one's family. So those items are all separate property. Those assets are separate property. Also, separate property is property that is subject to a premarital agreement or a postmarital agreement, so long as the agreement is enforceable and it specify that this property or this asset is in fact separate property during marriage.
I see. So let me ask you about what tends to happen if a couple starts to, let's say, mix separate funds with some of the marital funds, or they place separate assets in like a joint title. What happens in those situations?
Well, those assets, so if you have a separate property asset, let's say you inherit money from the passing of one of your parents. If you take those funds that you received and you deposit them into a joint bank account, so a bank account titled in your spouse's name, then that asset is going to be deemed a gift. And the likelihood is that if one goes to court, a court is going to say, yes, this was a gift and you have commingled that asset and it is no longer separate property. It is now community property subject to division.
Okay. What about then in the cases of like retirement accounts, 401ks, pensions, investment portfolios? How does that get divided in a divorce? How do the courts look at that?
Good question. And one thing for folks to remember is retirement accounts are often overlooked and omitted assets, even though, especially if it's a pension account, that is probably the largest asset of the community. And the way that retirement accounts are divided is subject to federal law with regard to the types of accounts and the orders that divide them. And then we have case law that has specified how those accounts are divvied up. And from a very high level, without going into detail that folks may make their eyes glaze over, what we do is we look at the length of the service during the marriage. We look at the length of the marriage, and then we divide that by 2. And that number, that percentage is going to be the other spouse's interest in that pension. So if you have a pension that a spouse has 100% of that pension was earned during the marriage, then 100% of that pension is going to be community property. If only 50% of that pension has been during the marriage, then only 25% of that is going to be the other spouse's right, approximately.
Great. Now I got to bust out my calculator, Shelly. So, well, well,
I try to keep the math very, very simple. It's a lot more complicated than that.
right.
And we have special pension division professionals that prepare qualified domestic relations orders, and other retirement division orders, so that
Right.
we make sure that they are done properly, and that we don't have a case that comes back 20 years later when parties have retired, and that has to be sorted. It's very specific rules, very specific ways these assets get divided.
Well, Shelley, they say for richer or for poorer in the vows. So, along those lines, debt is something that I'm sure surprises people with respect to how that gets split up. What kind of debts are considered part of the community obligation?
All debts acquired during marriage are community obligations. So we're talking house debts, home equity lines of credit, credit cards, um, car loans, eh, plastic surgery if it's acquired during marriage. All of those things are community debts. And provided those debts were used for community purposes, then the court is going to deem those to be community property, and they are going to be subject to division. Now, one catch with the division of debts is oftentimes debts are secured or associated with a third party creditor. And you can have a divorce decree that says, well, this debt belongs to this individual. But if the agreement isn't with that individual, it's with the other spouse, then the creditor is going to disregard it, and we can get into a bit of a mess. So what we often try to do is we put each debt with the individual whose name it is primary on the obligation, and we see where those numbers end up, and then we try to equalize with property, or worst case scenario, we will or we will assign that debt or a portion of that debt to the other party, even if it's not in that person's name. But we have to be sure to include some protection language in the event that the party who is not obligated with the creditor for that debt, to make sure that they comply with it. And if they don't, that there are enforcement provisions.
Shelley, you mentioned home a second ago, home loans. Some couples, they own a home together, sometimes before, sometimes obviously during the marriage it's acquired. What are some of the factors that kind of matter when determining each spouse's share of equity in the home?
Well, when we're looking at houses and what the equity is, the marital home is likely going to be deemed to be community property. However, if we have a marital home that's only titled in one party's name and the parties were married at the time it was acquired, what the court is going to look at is, why weren't both parties on the obligation or on the mortgage obligation? And what often comes out with that situation is that one party's credit was not such that they would qualify for a home loan, or it was a refinance and only one party's name was on the obligation. But if both parties are contributing to the mortgage, then it's likely going to be deemed community property. And in the event that a residence was acquired prior to marriage, and then the parties began living in it, and we had a refinance, or it was lived in for a long time with both parties contributing, what we do is we have a formula called Malmquist that determines the separate share versus the community share. And I'm not going to go into that math. It is a very complicated formula. And when we use the Malmquist formula, we usually do it a number of times to make sure that we get a consistent answer, because it's complicated.
Right. Well, we appreciate that saving on the math. You can go find out more about that in just a sec. Let me ask you though. One thing we haven't talked about is if a spouse owns a business or if a business is started during the marriage. Like, how does the court kind of look at that? Look at the business's value as part of the community estate. Break that down for us.
That's a great question, Mike, and it's one that we often deal with in family law, where parties have formed a business during the marriage. And when we're looking at that situation, we have more math. And attorneys are not known for their math skills. That's why we went to law school. So when we have substantial businesses, we have to hire what's called a business valuation expert. And there's a couple different ways that can be done. Each party can hire their own business valuation expert, or we hire a joint business valuation expert, and that professional comes up with the a couple different scenarios as far as the value, and then we use that number to come up with the value of the business for purposes of community property division.
Okay. May have to rename the pod to More Math with Shelly Cooley, but we'll leave
No,
that there.
no math with Shelly
No
Cooley.
math. Well, Shelly, as we put a bow on today's episode, the unfortunate part in all of this is that someone is preparing for a divorce, right? So, as we leave them a final message here for someone that's listening to this and they are starting to prepare divorce, what are some like practical steps you would advise them to take to kind of organize their financial picture so that way all of this property division process, assets, all of that is a little bit smoother and a little less overwhelming for them?
One of the biggest things that a party can do to help with divorce proceedings is to make sure you have at least a copy of each account statement or login so that you can access account statements. Because when we're talking about dividing assets and debts in a divorce, if we don't know what the assets and debts are, it's very difficult for your attorney to give you an idea of where things are going to land and how things are going to look. So whatever information as far as assets and debts you can get your hands on, get copies of that information so you can provide it to your attorney, or at least have a general idea of what you have so that we can ask the correct questions and get that information, so that we can make sure that your assets and debts are divided in an equitable manner.
Shelly, thank you for the time, the insights, all the math. We truly appreciate it as always.
Thank you for having me, Mike.
And thank you to everyone out there for listening to this installment of Building Families, Bridging Differences, a Family Law Journey. If you want to learn more or you want to schedule a consultation with Shelly and her team, visit CooleyLawLV.com. Don't forget to like, subscribe, leave a review, and comment. Share the episode with someone who needs to hear it. I am Mike Leon. We will see everybody next time.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.